My name is Brian Raphan. I'm a lawyer in the Penn Plaza area, specifically on 7th Avenue and 30th Street. I've been practicing for about 30 years, and the focus of our practice is wills, estates, and elder law. We have a relatively small office. We have about 15 people here, which includes 6 lawyers and then some support staff. Some of you we've dealt with, some of our other office attorneys have dealt with, looking at the names and the people. So we're here to help. We will answer questions from time to time. If you have them, you can call. We don't charge for a periodic phone call. If you call us all the time, we'll probably need to come up with some arrangement, but certainly we're happy to elaborate on anything we're talking about now. I see we have a few people still joining, but we're going to begin because we're a few minutes after. We have about 15 people on, I think, which is not particularly a lot. It's a good amount because it will give us an opportunity to take questions as we're going along. So if you have any questions relevant to what I'm speaking about at a time, you can chime in, and if it's a good time, we'll answer your question. I'm going to talk to you a little bit about the planning documents that most adults have. I'll talk to you a little bit about Medicaid, which is a form of public benefit welfare. And I'll talk to you a little bit about revocable trusts. I understand that you all live in a co-op, which is a private co-op, which becomes relevant with your wills and trust planning. The first document I want to discuss is a durable power of attorney. Power of attorney, as you may know, is a document where you appoint somebody else to act for you in your place if you become incapacitated or unable to handle your own affairs. Typically, you would, in priority, you would appoint a spouse or maybe children. If you don't have spouse and children, you may appoint a friend, your accountant, your lawyer, or somebody. And the purpose of the power of attorney is to make sure that your affairs are handled by a person that you select. If you don't have a power of attorney, you haven't designated somebody, in most simple terms, let's keep it non-catastrophic, and you're traveling out of town and you need to have your rent paid, or you need to have a bill paid, you have nobody to do it. Well, that seems simple enough. These days you could sort of pay things remotely and electronically, but in catastrophic terms, if you become incapacitated and you have no one that you've designated as power of attorney and you can't do it remotely or electronically, without a power of attorney, you typically would end up in the court system and in the process of what's called a guardianship proceeding. And I'll talk a little bit about a guardianship proceeding in a moment. But further, with the power of attorney, there are a few types of power of attorney documents. There is a durable power of attorney, which is the one that we always use in adult planning. Durable power of attorney means that if you become incapacitated, the person that you appoint can still act for you. If you give me a non-durable power of attorney, or your spouse a non-durable power of attorney, and you become incapacitated, that spouse or child or whoever you designate has no authority. The power of attorney is vacated and void. So it's always very important to make sure if you're issuing a power of attorney that you're using a durable power of attorney. There's also what's called a springing power of attorney. Certainly if you're appointing your spouse, or hopefully if you're appointing your spouse, there's no issue of trust. You'll give them immediate authority. You want them to be able to do everything now. If you're appointing a third party or a stranger, or your accountant, you're a lawyer, your rabbi, your priest, someone maybe other than a family member, you might want to put some safeguards on it. And you could put a safeguard that makes that power of attorney only become effective if your doctor says you're incapacitated. So if you give that power of attorney and they go to the bank to try to pay your bills or try to use it or try to take your money illegally, of course, they would not be able to do that without certification from your doctor that you're incapacitated. Now, the whole power of attorney conversation is very timely because COVID has brought about some changes. And the changes is the governor enacted some legislation earlier this year, which totally changes the power of attorney documents as we use today. Starting June 13th of this year, there will be a new power of attorney form. I say form because until June 13th, the power of attorney that we use is what I mentioned, statutory power of attorney. If you open up the law books of the state of New York, you see an actual picture or the printout of the power of attorney. We're not creating it. We're not developing it from scratch. The meat and potatoes of it is in the statute. And what's going to happen after June 13th is there's going to be a new form, if you will. And I say that because a power of attorney doesn't have to be complicated, or at least they're making these changes to make them less complicated. But it's important that if you do execute one, you're executing the right form based upon the right statute or law in effect at the time. Now, the first thing, again, with the power of attorney is having the correct agent, having the correct person you've appointed. So, okay, your spouse, your children, your whoever. The second thing is whether it's going to be an immediate authority or a springing authority. Do you want your doctor to be a safeguard to it, to only give that person power if you become incapacitated? So now you execute the power of attorney. When you look at the form, if you will, there are a number of powers. You could appoint your agent simply to handle your check writing. You could appoint your agent for the sole purpose of making your required minimum distribution payments. You could name your agent for the sole purpose of transferring ownership of your apartment. You can pick and choose and customize the powers that you want to give. Typically, in the practice of elder law or adult planning, if you're picking someone you trust, you want to stay out of the court system, and you don't want to become a ward of the court, you want to give as broad powers as possible. It's person specific. You can give any powers that you want. Right now, if you want to give your agent the power to make gifts, there's an entirely separate 10-page document, which is called a gift writer. And that document has to be witnessed and notarized in addition to the power of attorney. One of the big changes on June 13th with the new power of attorney legislation is they are doing away with this concept of a gift writer. So, okay, now you have your power of attorney executed. Hopefully it's the right document, it's the right form, and it's customized to you. How does your agent use it? Well, if you become incapacitated or you need your agent to act, your agent goes to the bank, introduces themselves. So this is in a non-COVID world where your agent can go to the bank, and the agent introduces him or herself to the bank. The bank records them, takes their ID, and records them as a signatory on your account. So sometimes the bank will immediately put them on, not often, not particularly these days, but with the new statute, they're trying to make it easier for banks to record and allow agents to act, because, historically, if the agent goes to the bank to record the power of attorney, bankers just seem to like to say no to anything you ask. They seem to like to give you a hard time. So I go in with the statutory form. I did it last week, and I say, I'd like to record this. They say, oh, no, this form's no good. Well, that's absolutely wrong. It's a statutory form. I didn't make it up. Of course it's good. So then I need to convince them to just take the form, send it to the legal department, and inevitably a week or two later, it gets approved. So it's a little bit of an uphill battle. With the new legislation, hopefully that problem goes away. Okay, so your agent goes into the bank, records the power of attorney, and now they could sign your checks. They could get duplicate copies of your account statements. They could do whatever you could do or whatever authority you give them to do. If you change your mind, if you don't want to give the power of attorney to the person you've given it to, you could revoke the power of attorney. You just sign a new power of attorney. It gets notarized, I should say. Power of attorney needs to be notarized by you or your signature. And you could revoke that power of attorney by just signing a revocation. If you do choose to revoke the power of attorney, if it's been recorded, it's a good idea or an important idea to let the banks know. Because if you revoke the power of attorney and say to your nephew, you can no longer handle my affairs, but you forget to tell the bank, your nephew could still go into the bank and make an inappropriate transaction or withdrawal from your funds. It's important to have, and I'm going to tell you a little bit about a guardianship proceeding, which is what happens if you don't have a power of attorney, how you could end up. We all have lots of bills in our life. We all pay our rent, our maintenance, our taxes, our utilities, our cell phone. If you become incapacitated and you're alone, if you have a spouse and you have a joint account, that's fine. The spouse continues to pay. I have many cases where all the assets are in one spouse's name. Maybe the husband is oblivious to the finances and the wife handles everything, and the husband's name is on nothing, or vice versa. So let's say the person handling the finances becomes incapacitated. and then the other spouse needs to pay bills, but he or she may not be on that bank account, may not be on that brokerage account. So then the problem becomes, how does he or she have access? Well, if he or she had a power of attorney, it would be sort of simple. He or she would go into the bank, give the power of attorney to the banker, and it would be recorded and have full access. And could even transfer money and take it into his or her name. Without a power of attorney, there is no access. So what happens is someone has to go to court and ask the court to give the spouse or the interested party, if you will, access. That's called a guardianship proceeding. A guardianship proceeding is a proceeding that takes place on Center Street downtown at 60 Center Street. We've all seen that impressive building. Someone makes a request to the judge by filing a little book report about you and says, Judge, this person's assets are frozen up because he or she has no capacity, or they don't understand what they're doing, or they think they have capacity, they don't, or they're a subject of a fraud in some way. They're just not handling affairs like they should. And the judge will review that book report. The judge may appoint a lawyer for you. The judge will appoint someone called a court evaluator to do an investigation. And all of a sudden, there's this big court case downtown about you. And inevitably, there will be a hearing, there will be testimony, there will be medical testimony or social work testimony or something about your incapacity. If you can participate, the judge will let you participate and be heard. But inevitably, the judge will select some person to handle your affairs. And right now we're talking about financial affairs. Of course, this also applies to medical decision-making, which I'll talk to you about in a minute. So the judge will appoint somebody. If you have a spouse, it doesn't mean the judge has to appoint the spouse. I have cases, we have a case right now, and this happens particularly in cases that there are assets. Sometimes there's a slant against the older you get, the system doesn't appreciate you as much. So we have a case where we were independent court-appointed guardian for a retired doctor who's about 85. His wife is 75, and the judge didn't appoint the wife. Why? I don't know. We weren't part of the proceeding. She seems nice enough to us. It is a second marriage case, so maybe sometimes that has to do with it. But the point of it is, the judge did not appoint the spouse. So now our office makes all the financial decisions and all the medical and personal decisions for this 85-year-old when he has a spouse living with him. Okay, we're following the judge's orders. We're doing it. We happen to think we're making the right decisions. The spouse typically agrees with us, but she could have got a guardian that would not participate with her and allow her to cooperate. We in our office find that cooperation is better, but there are good guardians and bad guardians. I happen to be an auditor of guardians appointed by the appellate court in the state of New York, and I audited about 100 independent guardianship cases, and they're not all good. Some guardians are lazy. Some guardians are cheap, even though it's not their money. Some guardians are thrifty because it's not their money. It's certainly easier to maintain someone in a nursing home than it is to maintain someone at home. So some guardians may have the theory that, you know what, he or she should go to a nursing home. It's easier, it's nice, they'll be taken care of, rather than going through the efforts to keep someone at home. If someone's at home, you may get a call at 11 at night that there's a problem that needs to be dealt with. You have bills to pay that are different from if someone's in a nursing home where you write one check each month to the nursing home. So generally, the premise is nobody wants to go to a nursing home. And the other premise is everyone wants to make their own decisions, or if they can't make it, they want to pick the person to make the decisions for them. So a power of attorney allows you to pick the person who's going to make the business and financial decision for you. If you don't want to do it, fine. You can leave it up to a judge. The court system in New York won't leave you abandoned. They'll appoint somebody, but nobody knows who you will get. I should say that a court guardianship proceeding probably cost anywhere between $10,000 and $30,000 from beginning to end, and you're paying for it. The judge is ordering it to be taken out of your account. And if the judge appoints a guardian for you, that guardian will be paid for by the court from your assets each year. So there's really not a great argument for not doing a power of attorney, especially if you have trusted people in your life. We sometimes hear, well, I don't really have anyone that I know that I trust. Okay, if you don't have someone, I understand it could be a problem. Like I said, you could pick a friend, your accountant, your lawyer, somebody. The person you pick shouldn't be older than you, shouldn't be sick, because they may be running around for you. They may be hiring your home care, firing your home care, arranging for vendors, arranging for deliveries, paying your Amazon bill. I mean, whatever the case may be. So power of attorney is only for business and financial part of your life. There's another part, which I'm sure most of you are familiar with. It's a healthcare proxy. A healthcare proxy allows you to appoint someone to make medical decisions for you. Again, if you don't have someone appointed and there is no one to make medical decisions, the guardianship can fit, and a guardian could make those decisions, but the goal being to stay out of the court system. You could appoint anyone you want as a healthcare proxy agent. They have to be an adult. It's always good to pick someone, again, who's capable, who has a good sense of your desires, who's rational, who's going to outlive you, who's going to be available to make medical decisions at random times. I had a case recently, about a month ago, a client of ours for about, she'd been a client for 20 years. She was 103, she died. And I handled her business affairs as a power of attorney, but she had appointed a friend as healthcare proxy. And at the end, we kept her home, and she was really great until 102, honestly. But in the past, and she wasn't in the hospital at all, ever, in the past 10 years, other than for occasional items, transient things. She went in the hospital, and we had a tough time getting the healthcare proxy to visit the hospital and step up to act. So pick someone who's going to be available, who's going to be compassionate. Healthcare proxy can make any medical decision that you allow them to make. Typically, it's from a critical medical decision to pulling the plug or not going on a resuscitator, to dental decisions, to anesthesia decisions, to medicine decisions. So whatever you empower your healthcare proxy agent to do, they can do. You could appoint more than one healthcare proxy. If you're not sure your first choice is going to be available, you could pick a second choice and a third choice and a fourth, and so on. That's totally fine. You can't, however, pick simultaneous agents. You can't say, I appoint my son and my daughter to be co-agents. That doesn't work. The medical world doesn't want your son and daughter arguing as to who has authority. They want one person to be in charge with an alternate. With a power of attorney, incidentally, you can pick simultaneous agents. You could have my son and my daughter. You could have my son and my daughter where they both have to sign the checks, or you could have it where either of them sign checks, or spouse and son, or spouse and daughter, whatever the case may be. For a power of attorney to be executed, like I said, it's signed and notarized. For a healthcare proxy to be executed, it's signed by you and witnessed by two witnesses. Your agents cannot be your witnesses. There's another decision-making document called a living will. A living will is not a statutory document like the healthcare proxy. It's a document of custom in New York, particularly. And it's a document which just states your medical wishes in the event you're in a terminal, irreversible deathbed condition with no hope of recovery, the type of treatment you want or the type of treatment you don't want. So we've developed what has become our form living will. It says something like, if I'm on a terminal irreversible condition with no hope of recovery to a meaningful life, to be able to participate in my decisions, I want to be comfortable. I want to stay home, or hospice rather than a nursing home. I want as much pain medication as possible. I don't want experimental surgery to keep me alive on a machine for the purposes of science. But the point is, you can customize it to your wishes. It's not a necessary document to the extent that your healthcare proxy agent could already make those decisions if you give them that power. But it's important sometimes for the healthcare proxy agent to have it, because it's a clear guide to them of what you would want. It's also a blueprint to the medical people of what you would want. So if you're in the hospital and they know you have a living will and you should stop breathing, the default is they resuscitate you. Even with this 103-year-old, they ask me, do I want to put a DNR on her chart? They ask me, I'm the power of attorney. Sometimes the doctors don't even realize the difference. DNR means do not resuscitate. And I give them a copy of the living will. If they don't have a living will, then they need to go to the next level. A living will stop them from resuscitating, and they'll follow the letter of your rules that you put before them. Again, like the power of attorney, you could revoke a healthcare proxy or living will at any time. If you decide that you want to be kept alive aggressively, there's nothing wrong with that. Everyone's entitled to their wishes. It should be stated in a living will, because otherwise somebody may say something to the contrary later. So to revoke it, you could either execute a new document, just saying I revoke my prior living will. I now appoint Brian as my successor, healthcare proxy, as the case may be. So those are simple form documents. I should say that a result, typically in the pre-COVID world, to sign these documents, people would come into our office, we would sit, we'd talk about them sort of like we're doing now, but it would be in person. Now, in the world of COVID, things have been made a little bit easier. The governor issued some executive orders that allow documents to be witnessed, which means signed by you and then signed by witnesses, and notarized remotely. We don't have to be sitting in the same room with the client when the documents are being signed. The way it works mechanically is we connect via Zoom or FaceTime. FaceTime is the iPhone version of Zoom. And we watch you sign. Of course, you need to be in the state of New York while you're signing. We identify you, we watch you sign, and then you transmit the document to us by fax or email, and then we can notarize on that transmitted copy. It needs to be transmitted to us that same day, and then you need to mail us the original within the next 30 days. And then we could notarize or witness, as the case may be, on the original. And that executive order was put in place specifically because there were people stuck in nursing homes that couldn't handle their affairs. And no one could even go visit them in the nursing home to have them sign a power of attorney, a healthcare proxy. So that's something that's actually very positive that's come out of COVID. Hopefully the executive order will be made permanent. That law that I just talked about with this executive order expires June 16th. It's expired before and it's continually been extended. My guess is it will be extended again, but I don't know. We usually find out at the last minute. We have another 2 or 3 weeks in that regard. The last advanced directive type document, and then I'll stop to see if there are any questions, is something called a MOLST, M-O-L-S-T. It's actually an acronym. It stands for Medical Order for Life-Sustaining Treatment. It's a detailed question and answer document that specifies particular circumstances and how you would want to be treated within those circumstances. And it's something that's completed and actually approved and signed in conjunction with your doctor. So the doctor would go through each particular instance with you. Often it happens, the nurse will go through each particular instance with you, and then the doctor will sign it and approve it. It usually comes up later in life where medical issues are more identifiable and imminent. In a general advanced directive way, the healthcare proxy is more typically used. But if there are more pressing or specific medical challenges, the MOLST is often used. And again, if you're interested in that, you could talk to your doctor about it, talk to the social worker, nurse, and they would help you do that. We can't prepare a MOLST without a doctor's involvement, so that's why we encourage clients to talk to the doctor first. Are there any questions regarding power of attorney, healthcare proxy, or living will, or a MOLST? Okay, good. That either means everybody's asleep, which is good too.
I had a question.
One simple question here. I think you kind of answered. It is possible to have more than one durable power of attorney for different functions. Somebody to pay the rent and somebody to take care of the medical.
Yes, absolutely. There are a few options with that. You could have multiple power of attorney forms appointing your son just giving real estate power, for example, appointing your daughter to handle your banking. That's one way, although the default language in the power of attorney form often states, I revoke other powers of attorney. So you would just need to check the language of your document. Alternatively, you could use one form and you could appoint your son and your daughter within that one form, and you could elaborate within the document saying your son should do this and your daughter should do that.
Thank you. Thank you for your presentation. Very clear and useful.
Sure.
Now, is there June 13th, these forms change? Is there?
Yeah, it does. And we'll be sending out an email blast about it. The legislature hasn't released the new form yet. I don't know, like they're waiting to the last minute. It's a little bizarre, but hopefully next week we'll see something and we'll do an email blast about it. We try to do very short, infrequent emails from the office just to keep people up to date on what's going on. So yes, June 13th.
So not to do something before June 13th.
Well, you can, if you raise a good point. If you have a power of attorney in place now, it remains effective. So the new law doesn't void any previously executed documents. You just have to, after the new date, you have to execute the right document from that date prospectively. So if you want to execute a document sooner, you can. Frankly, I would wait because it's supposed to be easier with the post June 13th document. So unless there's a pressing need, I would wait at this moment.
A question. I don't know if I'm unmuted. Yeah, I'm unmuted.
Yep, we hear you.
I was told by somebody that banks sometimes refuse to accept an executed power of attorney, that they recommended that you go to your spouse's bank and get them to give them that bank's form, because you'll have no problem with their own form, but otherwise not. And also I went to my husband's bank, and what do you know, they didn't have a form. So he went to my bank. He's all right with my bank, but you know.
Yeah, that's pure malarkey, to be appropriate. The person you spoke to had no idea what they were talking about. The statute says it's a misdemeanor for the bank. It says unlawful for the bank not to accept the statutory form. And in fact, the new legislation is going to make it easier for banks to accept more varied types of forms that don't exactly comply to the statute. Even if you walk into one that's an exact picture of the statute, they're so annoying at the banks. They just follow rules blindly. They don't ask any questions. Oh, my supervisor said we only take the bank form. Well, your supervisor's wrong. It happens to me so much.
You had to pry it out of them. You know, you basically, maybe you could do it, but it would take a lot of prying.
Right. Because they're looking for the easy way out. That's all. That's all. We often keep a copy of the statute handy in a PDF. And when a client calls with that, we email them a copy of the statute with a cover letter. So the banker who gets it then says, oh, maybe I should give it to the legal department. And I want to tell you, the people in the legal department, not that lawyers are special, we're not different. We just know certain things. The people in the legal department are paralegals. They're not, you can't even talk to a lawyer in the legal department. They won't get on the phone with you. So, you know, at some level, you're going to be frustrated. It's just a question of how much. Listen, it's a lot less frustrating than a court-appointed guardian who doesn't care about you, who doesn't even want to answer your phone calls. So there's a show on Hulu or Netflix or one of these things now, which seems to be viral, about some court-appointed guardian who exploits her ward, and everyone seems to love it. That people have told me to watch it. I haven't watched it because I live in that world every day, and I don't want to watch it because I'll just get myself angry about it. But I don't know if any of you have seen it, but I'll figure out the name of it, and maybe you should all watch it, and then I'm certain you'll all figure out who to pick, you know? Yeah. So any other questions at this point? Okay. There is one other advanced directive I want to mention. It's called the appointment of an agent to control burial. If you die, who has a right to bury you? Everyone just assumes it's your executor if you have one, and we'll talk about that. If you have a spouse, it's easy. You have children, it's easy. But if you don't, who's going to do it? You could appoint someone. If you want your friend to handle it, well, your friend doesn't have the right to handle it. If you want your significant other who's not a spouse to handle it, he or she doesn't have the right to do it automatically. There's a pecking order in the statute that says it's your spouse, your domestic partner, your children, your parents, your siblings, your court-appointed guardian. Oftentimes that's not the case. I had a situation once with a religious Jewish woman, a client, and she knew that her family would not allow her to be cremated. She wanted to be cremated. So she appointed me as her burial agent. So I followed her specific wishes. If she didn't do that, I could not ensure that she was cremated. Putting it in the will doesn't make it so. It's called the appointment of agent to control disposition of remains. It's signed by you. You put your wishes in it. It's signed by your agent. It's signed by witnesses. Again, relatively simple, straightforward document, but it's not good unless you execute it. With regard to disposition of remains, I'm just going to talk briefly about prepaid funeral. Clients often call asking should they prepay their funeral. I tend to think, it's a morbid subject, but it's all morbid. I think it's a good idea because I've seen people buried or disposed of in some way that they wouldn't necessarily want. And if something happens to you, why does your survivor want to deal with the business of dealing with a funeral home is really just the business and charging at such an emotional time. They're not listening. They're just saying yes to everything, yes to everything. So if you could find the ability, emotional strength to make pre-arrangements for your burial or funeral or cremation, do it now. I tend to think there's an economic savings because you're not going to be oversold. They know you're not a rush customer. They could know you're shopping. It will be exactly what you want. Sometimes when the family is arranging a funeral, there's a modicum of guilt. They may say, oh, let me have the more fancy coffin. Well, maybe you just want a plain pine box, or maybe you don't. I've had funerals for $75,000 at Frank Campbell on Madison Avenue, or I've had funerals for $2,500 at Redden's on 14th Street or Bleecker Street at Greenwich Funeral Home. So I would urge you to do that. There are two types of prepayment funeral. One is called revocable and one is called irrevocable. You could do it revocable. You change your mind, you get your money back. You decide not to die, you get your money back. We'll talk about the irrevocable prepaid funeral when we talk a little bit about Medicaid. So, I'll jump right into Medicaid now. Is anyone interested in Medicaid before I talk about it? It's a free home care potentially, or free nursing home care. Not that anybody wants to go to a nursing home, but Medicaid, anybody?
Yes.
Okay. So Medicaid is a government-funded program, state and federal funded, where if you have medical need and of certain financial qualifications, the government will support you. They will support you by paying your nursing home bills. Incidentally, a nursing home in New York is certainly $20,000 a month. Or they'll support you by giving you free home care, free medication. Now, to get free home care is much easier than to get free nursing home care. I'll focus on the home care part because that seems to be what's of more interest because presumably you want to stay home. But briefly to tell you, with the nursing home, you have to give them a 5-year financial history of all of your account statements, your tax returns, and a plethora of additional information because the nursing home wants to see if you've given money away. And they want to see how you've spent your money to make sure you haven't given it away. They want to see copies of your canceled checks. If you've been stooping or giving away money to your children, they want to know because in the world of Medicaid and nursing homes, that's not allowed. That's a no-no. Just because you're allowed to give a gift for gift tax purposes, you're not allowed to give a gift for Medicaid purposes. So the nursing home process is very voluminous. It's time consuming. Most people don't have the statements. They have to go to the banks and get them, or their power of attorney agent needs to go to the bank and get them because presumably if they're going into a nursing home, they are probably incapacitated. So Medicaid nursing home, if you have a spouse in New York and a spouse and one of the spouses needs to go to a nursing home, there's a very good technique in New York. It doesn't exist in New Jersey, doesn't exist in Florida. It's called spousal refusal, We transfer all the assets into the name of the well spouse, the non-nursing home spouse. And through some processes, we can get Medicaid approved for the nursing home spouse. Unless anyone has specific questions about nursing home Medicaid, I'll talk more about home care Medicaid. Any nursing home Medicaid questions? Okay, that's good. Glad you all plan on staying home. Budgets are tightening to get Medicaid for home care purposes. It's a three-step process. First, we get you financially eligible. Unlike nursing home Medicaid, where I said they look at your finances for 5 years, for home care, they look at your finances for 1 to 3 months through the remainder of this year. After December 31st, there will be what's called a look back period or a review period for home care Medicaid. So if you're on the cusp of thinking that you may need it, very important to do it this year because it's going to get much more difficult to do it next year. So the first step is we make sure you're financially eligible. If you have $50,000 or $80,000 or $8 million, we need to transfer money out of your name. Well, if you have a spouse, that's an easy one, hopefully, transfer it to the spouse. If you have children, hopefully it's an easy one, maybe transfer it to the children, or maybe transfer it to a trust. There's advantages and disadvantages to each. We can talk a little about those if it becomes relevant, but inevitably to submit the application, we have to show your assets at less than about $16,000. That's called a resource test, assets or resources in Medicaid lingo. For income purposes, you have to have less than around $885, give or take, of monthly income. If you have more, we could still get you Medicaid, but you have to join what's called a pool trust. So if you have income of $1,800 and you're only allowed to have $800, while you're on Medicaid, every month that you're on Medicaid, every month you'll pay $1,000 to this pooled income trust. The good news is the money's still yours. The trust holds it for you, and whoever's handling your day-to-day, presumably your power of attorney, your spouse, your children, send in monthly bills to the pool trust, and they use that money of yours that they're holding to pay your bills for you. So we get you Medicaid eligible by way of financial. We check your income, determine what your excess income is that goes to the pool trust. We get your assets onto the $16,000. We join you into the pool trust if you have that excess income. Those are not-for-profit organizations. There are many of them that are good. Okay, then we get you approved for Medicaid. Then there's an interview where Medicaid will visit with you to make sure you need home care. That's the only purpose. They just want to see, is it a home care case or not a home care case? It's an easy threshold. Typically, if we're applying for Medicaid, someone needs home care. We don't typically apply unless someone needs home care. So that visit takes place, then they approve you for Medicaid home care. The third and most complicated or challenging visit is an interview visit with the Medicaid home care provider to determine the number of hours of home care that they will offer. You could have this third visit with as many providers as you want. We had a case about 6 months ago where the client is bedridden. She can't do anything. We had to visit, and the home care provider offered 6 hours a day, 7 days a week. Well, that was not sufficient. So we had the same interview with 3 other providers, and one of the providers offered and provides to this day 24 hours a day, 7 days a week. It's not easy to get 24 hours a day, 7 days a week. It used to be easier, but with the tight budgets, it's not easy. But before those interviews take place, we try to give our clients some tips on what to say, what not to say. Sometimes clients say, "Oh, I'm fine. I did 10 push-ups this morning." That's what not to say. You don't want to do that. The issue comes up back to resources. I know you all live in a co-op. What happened? How does it work? Well, there are some excluded assets or resources when it comes to Medicaid. Retirement accounts For those that have them in pay status, which means you're over 70 and a half under the current law, or 72, you're receiving required minimum distributions, those assets are exempt. So you could have $1 million in a retirement account and $10,000 in a checking account, and you are Medicaid eligible based upon the resource test. You could have a co-op apartment worth $1 million. That's okay. It's not liquid. You are Medicaid eligible under the resource test. Now, I will say that once you get Medicaid, Medicaid keeps track of how much they're spending on your behalf. Medicaid pays a home care provider. So Medicaid keeps a tally. When you die, if your estate is filed downtown with the courts on Chambers Street, Medicaid will file a lien against your estate and ask or seek to recover what they've advanced on your behalf. So if your executor goes to sell your apartment and sells it for $800,000, Medicaid will say, hey, you owe us $160,000, repay us first. So in a perfect world, we want to avoid the courts in that situation. So you could avoid the courts in one or two ways. So one is not own the apartment when you die. And when you die, if you don't own the apartment, the lien does not attach at your death to the apartment. How do you not own the apartment? Well, you could put it into a irrevocable trust. Irrevocable, which means once you do this trust, you can't change your mind. However, you could retain the absolute right to live in that apartment for your lifetime. So if you're appointing your trustee as your son as your trustee, or your spouse as your trustee, it would be more typically a son in a case like this. They would get it when you die, but you own it only in your lifetime. And that trust would say, upon your death, the asset passes directly to who you specify. It could be your children, it could be your brother, sister, or charities, or whoever. The point of it is that asset does not pass through the court system. And because it doesn't pass through the court system, the Medicaid lien does not attach because the asset was not in your name. If you keep the apartment in your name, then the lien will attach. If you have a spouse, you could transfer the asset to the non-Medicaid spouse. No problem. You're always allowed to give assets to your spouse for Medicaid purposes and for gift tax purposes, for that matter. There would be no lien attaching to the surviving spouse at your death. But it's always better if you have kids that you trust, and not, unfortunately, it doesn't always play out that way, but it is what it is. It's better to go down generationally because maybe that surviving spouse will need Medicaid later. Question always comes up, is Medicaid home care good? How about private pay? Medicaid home care is free. Free is always good. Sometimes you get what you pay for and sometimes you don't. If you have the luxury of unlimited money or resources and you could pay for your home care, maybe that's fine. Medicaid workers tend to be a little more rigid. If you have a Medicaid home care worker and you say, oh, by the way, can you run down and get my dry cleaning? They may say no. The agency won't let me do that because they're not there to do that. They're paid by an agency which is paid by the government to do only the home care. If you have a private worker, there's often more flexibility because they're really working for you, whatever you need, not necessarily just the strict home care route. They're there maybe as your personal assistant, maybe their services would go a little broader. If you have spouses and your spouse has Medicaid and you ask the Medicaid worker to do something for you, they may say, no, I'm not here to work for you. The truth is we've had fantastic experiences with some Medicaid home care people. They are working for you in the sense that if you don't like them, you could call the agency and you could ask them to send someone else. You can do that a few times. You can't continually operate as a revolving door, but it is a workable situation. Based upon the fact that it gives you a viable option to stay home, it's an excellent consideration. Anyone have any questions about the Medicaid home care, either application process, financial qualification, or how it works once you have it?
Yes, I have a question. If the person you have is your person who makes the decisions, so if something happens to them, if like your son or your daughter became ill, had an accident, can you, and you have an irrevocable will, what trust? What happens?
Yeah, that's a good question. Typically, the document would have some contingencies for that. Say who would be the successor. If it doesn't, there's often a workaround where you can get all the interested parties to agree to revise the document. So it would be based upon, we'd have to look at the wording of the document. When we create documents, we like to have a contingency plan, because one thing for certain is that nothing is certain. So if you have a situation where that's come up and you want me to look at it, we wouldn't charge. Just email the document over and I'll tell you what viable options you have. But as a last resort, the court is always there to reform a document or to appoint someone. But when you hear court, it's slow, it's expensive, and it's better to stay out of it. That's why we try to do an appropriate contingency plan. The remaining item to talk about that everyone probably knows about is a will. You all own apartments, I think, or most of you do, in that what used to be like a Mitchell-Lama type of co-op or something similar, which is great. It's interesting because you have these apartments where you were living for years and you paid your equity when you moved in and it was a good deal. And then it went private and now you have an asset. But they don't tell you that your maintenance necessarily goes up. So now you're paying more each month. So now your cash flow is impaired. And you're only leaving a bigger inheritance to your children, which may be fine if that's what you want. I like to try to encourage clients, quality of life is more important. Your kids will be fine. That's theirs. Where our focus should be you. Now you have less monthly cash flow because you're paying more maintenance. You have other issues, maybe repair items in the apartment, which used to be a responsibility of the co-op is now your responsibility. And what do you do? So you have these assets and you could leave them to whoever you choose in a will, a last will and testament. Not a living will. The living will is for medical purposes, applies while you're living. Last will and testament is a document which it speaks as of the moment of your death, and it allows you to give out your estate. You say who gets what and how they get it. And it also says who's going to give it to them. The who's going to give it to them is the person who you name as your executor. The executor steps into your shoes and carries out the terms of your will under some loose court supervision. The first step, I say court supervision, because for a will to be valid to pass your property, for your executor to get any authority, the will gets filed with the court with your death certificate, some additional documentation, and then the court will appoint the executor officially. The executor can now sign for you. The executor can do anything that you were able to do, he or she can now do. I say he or she, I mean, you could appoint a bank as well, but banks usually take cases that are worth millions of dollars because they're in it to make money. They're not going to take an estate of a few $100,000. It wouldn't be in their economic interest. You could appoint anyone as your executor. Spouses are good if they're healthy. Children are good if they're healthy. It's always good to stay in the family if you can, because if you appoint an outsider, they get a fee. When we're appointed executor, the New York statutes, the laws of the state of New York specify the fee for executors. Family often doesn't take it because it's family. But when you appoint a professional, they take it. It's the business. The fee is 5% of the first 100,000, 4% of the next 200,000, 3% of the next 700,000, and then it goes down from there. But whoever your executor is doing work. You know what it's like to manage your life. Some people are very organized and it's maybe not that difficult to manage, but more often than not, people's affairs aren't as organized as we'd like. And we find ourselves on a little bit of an asset chase and dealing with the banks and closing the accounts, dealing with the apartment, cleaning of the apartment, inventorying of the contents, appraisal of the contents. distribution of the contents, if you're giving it to various people over throughout the United States or further, shipping of the contents. So it could be a tremendous amount of work. So when you think of who you're appointing, if you're appointing your son or daughter who's an international banker who's traveling 300 days a year, I get it. Maybe it's a good choice, but maybe it's not. If you're appointing your spouse, it may save you money. It may be comfortable. Is it the best move? Does he or she really want to do it? Or if they want to do it now, will they be able to do it maybe in 10 years when something happens, when death occurs? Keep in mind, we do these documents, we build in contingencies, and sometimes clients don't revisit their documents every few years. So the spouse may have been well when the document was done, but times change. We're all getting older as we sit here. So it's something to think about. So everybody seems to procrastinate with a will. You have to be competent to do it. It's a formal statutory document. It's got to be signed by you in the presence of two appropriate qualified witnesses, meaning got to be over the age of 18. Witnesses cannot be beneficiaries of the will because that shows a bias. I will say that there is also this executive order that I mentioned earlier with remote execution also applies to wills. So you could execute your will in your apartment. Your witnesses could be in other places in the state of New York. It's interesting. I don't know. I'm imagining it's going to lead to a lot of litigation for certain people, not in close family wills where everything goes to the children, the spouse. We usually don't see fights in cases like that. We see fights in second marriage cases where everything goes to the second spouse and maybe nothing to the kids of the first spouse, things of that nature. If you don't do a will, the law of the state of New York will write it for you. It's called an administration proceeding. And instead of having an executor, you will have an administrator. The court will appoint that administrator. And there's a priority as to who gets appointed: spouse, children equally. So if you have 4 children and one of them is not great, that not great child has an absolute right to be the administrator despite what you want, because you haven't done a will, and the assets would be divided accordingly. If you don't have a spouse and children, it goes to parents. If your parents are not around, it follows the whole family tree all the way down to first cousins. So you may find that people you don't want inheriting your estate are inheriting your estate. So there's really not a great reason not to have a will and specify with detail who you want to be inheriting your estate. If you have a disabled beneficiary, it's important to have a will, because if you leave money outright to that beneficiary, he or she may not have the capacity to manage that money. They may get frauded from the money. They may be at a disadvantage with that money. You could leave them money in the context of your will in a trust, which we lay out in your will. It could be what's called a supplemental needs trust, which allows that beneficiary to get Medicaid benefits in the future. So they could have $1 million parked in this supplemental needs trust, and they could still get Medicaid benefits, free home care, group homes, things of that nature. So it's helpful. In your will, you can give out your family heirlooms. You can give out your artwork, however you want to specify it. It's something that is tailored to each individual person. Wills, for the average person under the present laws, taxes and wills or taxes and death is not that much of an issue under the present law, because there's no federal estate tax until after approximately $11.8 million each. So most people don't even have $11.8 million for one person, let alone for a husband and wife. If you do, that would make your will more complicated. For New York State estate tax purposes, the tax threshold is about $5.8 million. The threshold for federal purposes expires or reverts to an older threshold of about $5.25 million as of January 1, 2026. There's talk by Biden about him wanting to raise some taxes, including changing the estate tax thresholds. Who knows what's going to happen? If we do draft for tax-sensitive wills, we try to provide for contingencies so you don't have to change your document if the law changes. I will say there's never an estate tax between spouses. You could leave $100 million to your spouse and there is no estate tax or death tax. So that's always a safe haven if you have a spouse. If you don't have a spouse, you don't have that safe haven. Other than that, with the will, I said you could change it at any time. How do you change a will? You could revoke a will by having the original in your hand and ripping it up. It's revoked by physical act. You could revoke a will by signing a document revoking your will, saying, I hereby revoke my will, and having that executed appropriately with the formalities. Or you could revoke a will by simply executing a new will. The first paragraph of a will typically says, I hereby revoke any prior wills that I've done to date. So thinking what else? As far as executors, they have to be a US citizen or resident green card holder. If they're not, they could serve as co-executor with a US citizen. We have an estate now I'm handling for one of your neighbors who happens to live by you. We're co-executors. There are 3 of us. One lives in New Jersey. The other lives in Spain. It's a little bit complicated because now everything is moving slow because we send documents to Spain. We ask her to get a notary. She can't get a notary. So things that would take 3 weeks are taking 10 weeks. Well, the US consulate's closed there, so sometimes even longer. Who would have imagined COVID delays that of course. So when you choose your executor, choose someone that's going to be practical for the whole overall circumstance. Let's see. Well, any questions about wills? Yes, I see you have a question.
If
Susan.
you create a trust, you include that in the will.
Yeah, well, there's a few types of trust. That's going to be my next subject, and we'll talk a little about it now. The trust that I mentioned is what's called a testamentary trust. It's part of your last will and testament. It's just framed at this point. It's not funded. It's just a plan. It doesn't have any money in it. So it doesn't get formed until you die. It's a part of your last will and testament. That's called a testamentary trust. And then you have a living trust, which is a trust that you form now and put your money in it now. And when you do a living trust, it could be revocable, which means you could change it at any time. You could take your money in, you could put your money, take your money out. You can do whatever you want to do. That a living trust or revocable trust does not provide any Medicaid assistance. Like I mentioned before, it doesn't impact Medicaid qualification. It will avoid the Medicaid lien on your death because there's nothing passing through the court system under the present laws. Who knows how that will change. And then you have an irrevocable trust, where once you put your assets in, your assets are in, you cannot get them back. You can often change who the beneficiaries are of that trust, but you can't get your assets back. So yes, I was referring to a testamentary trust.
But what's the plus in the last will, a trust that you said?
Well, an irrevocable trust would ordinarily be used if we wanted to apply you for Medicaid and we wanted to avoid the Medicaid lien. And we thought a nursing home, for example, we wanted to hedge against the nursing home. Because if you have a revocable trust and you go to a nursing home, you need to liquidate everything in that revocable trust, and essentially it would be paid to the nursing home. At $20,000, $25,000 a month, that would go pretty fast. If you have an irrevocable trust, and we've overcome the 5-year period, let's say you form an irrevocable trust for your apartment today, and in 5.5 years you need to go to a nursing home, well, they're not touching that. They're not touching that trust asset. So you've taken potentially $1 million, if it's an apartment worth $1 million, off the table. And you retain the right to live there. But one thing for sure is Medicaid cannot touch that trust. So that's when an irrevocable trust is often used. Irrevocable trust is more for asset protection, to protect from creditors. A revocable trust is more for property management, just to avoid the court system. To tell you a little about the court system, when you die, for a will to be valid, as I said, it needs to be filed with the court and probated. Probate is the process of validating a will. To probate a will, the court wants to get jurisdiction or consent, if you will, either by non-objections or affirmative consent over the next of kin of the decedent. So if you have a spouse and children, your next of kin are your spouse and children. If you have no spouse and children, it's your parents. If your parents are gone, it's your brothers or sisters or nieces and nephews, or again, out to first cousins. If we're not able to say to the court who the decedent's next of kin are, the probate proceeding is going to be delayed and it's going to be expensive. So if we have someone like this comes up all the time here in New York, if we have a case of a Holocaust survivor and we don't know who the next of kin is because they lost a brother in the Holocaust, but we don't know for certain, or there's only first cousins, the court requires us to do what's called due diligence. We have to do genealogical research and submit to the court due diligent efforts, what we did to try to determine who the family members of this decedent are or were. And once that's done, the court will say, okay, that's fine. Publish it in the newspaper just to give if there is family, just so they have notice. In New York County, the court tells us to publish it in the New York Law Journal. I don't know how it could be, but it's $9,000 to $10,000 to publish that advertisement in the New York Law Journal. It's insane. In cases like that, maybe we would do a revocable trust because then we're avoiding the court system. It costs more upfront, but it saves a lot on the back end. It really does.
Yeah.
Okay, well, listen, if you have any other questions about anything, I could certainly entertain anything now. If you have a question that you want to follow up with, please feel free to reach out and we'll see if we could answer you either by me or one of the other lawyers here. We'll get back to you. I will say, if you reach out to me through next Wednesday, my schedule is a little difficult, so I would probably prefer to get back to you after next Thursday or forward. I have a very contentious family guardianship proceeding where everyone's fighting over control, or I should say that control is a euphemism. They're really fighting over money. So because the person didn't do a power of attorney and healthcare proxy, and it's a complicated family dynamic. Thank you all for joining. It's really been nice to have an opportunity to speak to you all. And Evelyn, thank you for putting this together. Really fantastic.
Thanks, Brian. Thank you, everyone, for joining.
See you all soon.
Thank you so much.
Thank you.